Be seated. We're still on the record. All right, a couple of things. I know the defense was in the process, I think, of making expressing a concern or an objection to counsel's argument belittling the defense. Is that what I correctly perceived that objection? I think we dealt with it sufficiently during the objections during the rebuttal. So there will be no additional instruction in that regard.
I do believe that it constitutes prosecutorial misconduct and is potentially basis for grounds for a mistrial.
Okay, I think the use of the word nonsense is what you're talking about originally.
Originally, Your Honor, but then in rebuttal there were repeated comments about how we were, and implications that we were shading was one example, that we were creating Halloween stories was another example, that these were stories, and that was a repeated comment. Stated that we misrepresented facts and put words into Dr. Baker's mouth, that we made several statements that they put forth as stories. After the court instructed him to stop using the word stories, he clarified that it's just fabricated facts. And so there were multiple references to that, that we were shading the truth, right? I mean, and again, so multiple objections. This is essentially governed by State versus McDaniel. The final argument to the jury of prosecutor is governed by a unique set of rules which differ significantly from those governing counsel in civil suits and even those governing defense counsel in the very same criminal trial. These special rules follow directly from the prosecutor's inherently unique role in the criminal justice system, which mandates that the prosecutor not act as a zealous advocate for criminal punishment, but as the representative of the people in an effort to seek justice. For example, that when a prosecutor argues that a defense is meritless, she cannot belittle the defense either in the abstract or suggesting that the defense was raised because it was the only defense that would succeed. So there's lots of law in this, Your Honor, and essentially these comments, the repeated comments, constitute prosecutorial misconduct.
I'll note for the record that I overruled the first objection when Mr. Blackwell used the word story because it was isolated and in its context it did not seem to me to be belittling. However, the continued use of it, I did sustain the ultimate objection that counsel made to the use of the word stories and instructed the jury to disregard it. Also on shading the truth, that I sustained the objection and instructed the jury to disregard it. I'm not making any findings as to whether it was the type of prosecutorial misconduct that would result in a mistrial. I think it was adequately addressed by the court's instruction to disregard. All right. With regard to other matters we have, I think there were some bench conferences that that are fairly historical that you wanted to memorialize, but also a new motion based on events this weekend. Mr. Nelson.
Correct, Your Honor. Your Honor, as the court is aware and as prior to coming into court this morning for closing arguments, we had an in-chambers discussion about events of this weekend, specifically referencing that an elected official, United States congressperson, was making what I interpreted to be, and what I think are reasonably interpreted to be, threats against the sanctity of the jury process, threatening and intimidating the jury, demanding that if there's not a guilty verdict, that there would be further problems, Your Honor. And given the fact that this jury has not been sequestered, it has been my position all along throughout the course of this case that this jury should have been sequestered at the outset. The jury has not been continually told to stay away from media, only media about this case. There is a high probability that members of this jury have seen these comments, are familiar with these comments, and things that have happened throughout the course of this trial. I mean, it's unfortunate that there was another situation that occurred during the course of this trial. But obviously, Your Honor, we also, as I mentioned previously too, one of the jurors does live in the city, Brooklyn Center, as I recall.
Although I think that is the alternate we just dismissed.
I do not believe so. I
thought it was, but go ahead.
I'd have to go back and double check my notes. So, Your Honor, I mean, I just think that the sum total of this trial happening in such a public context, number one. Number two, while all of this, I mean, the media attention is profound. I have admittedly stayed away from 99% of it, but that has required me to stay away from all media. I mean, this case has found its way into even fictional television. Your Honor, there were I was advised of 2 television shows in the course of the past few days that specifically involved references to this particular case and the reactions of the characters in these stories to this particular case. This jury has, despite all best efforts, has been bombarded with information relevant to this case. It is impossible to stay away from it unless you literally shut off your phone or you shut off your TV, you shut off your computer. And no such instructions have been given during the course of this trial.
Well, to be fair, the last few times I've advised them, I told them don't watch the news. Pure and simple.
Right, but if you can't even watch your favorite Thursday night television program and it comes up, I mean, this is the problem, right? And why I have felt that this jury should have been sequestered from the very beginning.
Understood.
To make that clear. And so I had moved